Okay, ladies and gentlemen, day two of our certificate in corporate governance law. Today we will try to cover three, four important topics. Hopefully it will take around 3 hours. Just let me know if you need a break. Otherwise, I will try to cover all the portions in 3 hours. The second topic which we are going to discuss is the theories of corporate governance. It is very important topic. Theoretical concepts, usually they are considered as boring by our law students, but we have a compulsory course at our Tashkent State University of Law related to theory of state and law. So theories of corporate governance, I will look into the theories, some of the very important theories, and I will try to connect these theories to the contemporary corporate governance world. But before that, it is very important to differentiate and to understand what is a theory. What is a theory and how it is different from philosophy and ideology. You might have heard these words, theory, philosophy, and ideology. These three things are different. So what is a theory? Theory is a set of principles on which the practice of an activity is based. What does it mean? It means that theory is guided. Theory is in a specific direction. Theory is a kind of proposal which helps us understanding of a social, political, or any phenomena related to our lives. So theory is a set of principles on which the practice of a new or any activity is based. For example, theory of state. If we try to understand how the state has been formed, we will talk about different theories. Yes, in order to understand how the state is functioning. If we want to understand the economic structure of a country, we will base it on different theories and try to understand how this economic system is working. So theory is usually directed, it is in a specific domain, and it helps us in understanding how this thing is working. Whereas philosophy is general and answers the fundamental questions. And another interesting thing about philosophy is that philosophy is very much subjective. Everyone can has its own philosophy. You can have your philosophy, I can have my philosophy. Your philosophy can be different from my philosophy about something. It can contradict, it can go parallel to each other. So everyone can have its own philosophy. Whereas ideology is a system of ideas and ideals, especially one which forms the basis of economics and political theory or policy. So ideology is a bit different from theory and policy. In my understanding, ideology is something which expect peoples to follow. For example, you are a great political leader. You are a great philosopher. You have your own philosophy about politics or economics. Now you want other people to follow you. You will lead people through your philosophy. So we will call it your ideology. Okay. So ideology is, it is a theory or philosophy, you can say, but the basic distinction is that you expect people to follow your ideology. Okay. So this is a difference between theory, philosophy, and ideology. So all of you are business students, business law, commercial law students. A very interesting situation happened in my personal life as well when I was studying finance. And in the final state exam, the examiner asked me a question. And I was very confident before the exam that I know everything. And he asked me the question that what is the difference between accounting, finance, and economics? So he asked me, what is the difference between accounting, finance, and economics? Yes, and it became very difficult for me to answer. So any one of you knows what is the difference between accounting, finance, and economics? Anyone? Or anyone wants to try? What is the difference between accounting, finance, and economics?
Uh, can I can I just try?
Yes, yes,
Because
please.
I'm not really sure. Accounting, it's more about numbers of salary or no, it's more about the money that operate in company. Finance, it's more about the income, outcome, and etc. And econ- uh, did you say economic strategy or something else?
Economics in general.
Economics in general, it's how it's all about accounting, finance also. It's general subject that covers everything. So in economics, it's more general, and accounting, it's more related to finance.
Yes, you are right. So economics is about everything, you can say, about all the available resources. Economics and finance is about distribution of resources. Who needs what? Which department needs what? It is about distribution of these resources. And accounting is the calculation when you put them into numbers. Okay, so this is a basic difference between them. But the idea is why I brought this example, that we use these words like theory, philosophy, and ideology, and we consider that they are the same thing, but actually they are different. Okay, so that's why I decided that before talking about theories, I will give you and understanding how these things are different. So the first theory which we are going to discuss is the social contract theory. All the lawyers, we have studied this theory in our compulsory subject of theory of state and law. So social contract theory is proposed by the legendary scientists, social scientist, and not only the social contract theory, but they propose many other theories as well. For example, John Locke is known because of his work with regard to the human rights. Yes. So who are the social theory philosophers? John Locke, Thomas Hobbes, John Jack Rousseau, John Rawls, all of these philosophers, they are considered as social theorists. So what is the idea behind social theory? Social contract theory is, social contract theory says that when there was no government, we were living in the state of nature. In the absence of government, we were living in the state of nature. So in the state of nature, everyone was against everyone. Everyone was trying to survive. Yes, it is one of the versions of social contract. So when we were living in the state of nature, we decided that why not to make peace? Why not to make peace by making a government? So what we did, we asked certain people among us to act as our leaders. So we made leaders among ourselves. And what we did, we asked these leaders that please take care of our rights. You will give us our rights, and in return, we will make sure that your regime or your government will work smoothly. So we gave them power, and in return, we expected that they will take care of our rights. So we made a contract with them. Once again, when there was no government, we were living in the state of nature. In the state of nature, we decided to make a government, and we selected certain people among ourselves and we gave them power. We made our leaders and we gave them power. And by giving them power, we were expecting that they will protect our rights and they will fulfill our basic needs. So there is a contract between leaders and ordinary members of the society, which is called as social contract. Okay, this is a very basic general understanding of social contract theory. Graphically representing, you can see that we the people we the people give power to these executive and judges. So we give our power to these people, and in return, what we are expecting these people to give us security, and take care of our basic rights, which are life, liberty, and property. So we, the people, select our leaders, executives, and judges, and in return, we expect them to take care of our rights. This is a contract between individuals and state, which is called as social contract, and the theory is called as social contract theory. Now, coming towards the business dimension of this social contract theory, uh, you can say that we, the members of the society, make a contract with the companies. We ask them to make profit. We give power to the companies to make profit, and in return, we expect these companies to do something good for the society and individuals who are living in the society. So there is a social contract type of thing between companies and individuals. In the corporate governance structure, if you want to apply this theory on the corporate governance, you can say that the investors give their money to whom? To the company, and in return, the investors or the stakeholders or the shareholder expect that their money will return back to them with profits. Okay, so we give money, we who, investors or the stakeholder or shareholders, we give money to the companies, we ask companies to make profit, and in return we expect the companies to return this profit with return this money with profit. So this is a social contract kind of thing between uh, companies and individuals. So a social contract is an act by which individuals agree to form a government. According to the social contract theory, governments are established by the people who combine to achieve some goal. Thomas Hobbes, John Locke, and Jean-Jacques Rousseau were social contract theorists. They hypothesized the existence of a state of nature prior to any government. So without government, we were living in the state of nature, and then we decided to make a government, and we made a government by selecting certain people among ourselves. We gave powers to them, and in return, we were expecting the protection of our rights. This is the social contract. So there are certain things besides right who have potential to make or to disturb our social contract. For example, oil and commodities, human rights and technology. For example, the countries who are producing oil has bigger say or upper hand in many matters related to international relations importance. Okay, so sometimes it happens that this contract between individuals and leaders disturb. For example, if you remember the Arabian Spring, the revolution in Middle East. It began from Tunisia when one individual he burnt himself because there was so much poverty, and this incident disturbed the social contract in whole Middle East, and people started revolting against their government. So there are so many other things which has potential to disturb this smoothly going social contract between individuals and leaders, or between individuals and the companies, if we are talking about business. So social contract in business, an important concept of the social theory contract in business is follow through, or making sure that business is holding up its end of bargain and not just paying lip service to the community. So we expect from the business that business is making money, making profit in our society, and also he is doing something good for the betterment of society. It should not be just saying that, okay, we are the business people, we are doing something good for the society, but it should be visible, it should be vivid for ordinary citizens to feel the benefits of these businesses who are making profit in the society. Corporate governance structures are policies that a company enacts to keep itself on an ethical and legal path. You can think of these structures as internal laws for the businesses. Corporate governance dictates the standards to which a company holds itself, the punishments that detractors from the standards incur. Corporate governance is therefore important for the keeping corporate philanthropy, corporate social responsibility, and the overall corporate social contract theory is at the forefront of a business strategy plan. So the idea is, in very simple words, that we people expect these businesses who are making profit in the society to return something back to the society, because there is a contract between individuals and the companies, which is a type of social contract. So we ask the companies, okay, you can make profit, but in return, do something good for us as well. This is a social contract perspective of corporate governance. The second important theory, very important theory, I would say the main theory of corporate governance is agency theory. Agency theory, ladies and gentlemen, very important theory in corporate governance. So agency theory is the dominant theory in corporate governance. Agency theory identifies the relationship where one party, principal owners, who are the principal owners in the business? Shareholders or stakeholders in general, they give their power to another party, to whom? Directors. So you can say that agency theory is a relationship between investors and the members of board of directors. So investors give power to the members of board of directors, and members of board of directors act as an agent for the principals. Who are the principals? Investors are the principals. Agency theory considers the form and effect of contracts which exist between individuals in firm. So different peoples in the company, they have an agent principal kind of relationship among themselves. So agency theory, once again, ladies and gentlemen, agent. One party appoints its agent, and this agent works on the behalf of the principal who has appointed him its agent. So for the sake of corporate governance, you can say that investors or the stakeholder, they appoint members of board of directors as their agent. So members of board of directors, they act in interest of the stakeholder. This is the agency theory. So background of agency theory, is why we need agency, or when we talk about background of agency theory, the question is why we need agency theory. So there are different understandings that why we need agency theory. Agency theory we need in order to eradicate satisficing. So what is the idea of satisficing? Satisficing is that minimum requirements necessary to achieve a particular goal. What does it mean? It's mean that if there is no agent principal relationship, if there is no agent principal relationship, we will do only what is necessary to fulfill the minimum requirements. We will not think about making profit. I will give you an example. So we the students, if no one is pressurizing us, if no one is pressurizing us, what we expect? We expect only 60 marks, because 60 marks are the minimum requirements to pass. Okay, so if no one is pushing you, then you will not strive, you will not struggle to get 90 plus marks. You will just try to get the minimum marks, which are 60 marks. Okay, so this is the idea behind agency theory, that if there is no principal agent relationship, if the members of board of directors are not pushed by the investors, or if the members of board of directors are not answerable to their stakeholders, they will do only minimum. They will just think about, okay, company is running, company is working, it's fine. Okay, they will not think about making maximum profit. So that is the reason we need a principal agent kind of relationship. The second thing is that X in efficiency. Okay, so ladies and gentlemen, economic terms, please bear with me. X in efficiency is the divergence of a firm's observed behavior in practice, influenced by a lack of competitive pressure from efficient behavior assumed or implied by economic theory. This is the definition of X in efficiency. In a very simple word, you know, it is also a psychological thing that we work under the competitive environment. Okay, so X inefficiency uh, talks about increasing the productivity. The product market competition will pressure firm members to produce more efforts so that the company produce more profits and more fortunate. Yes, so these are some of the backgrounds that why we need certain why we need a relationship, principal agent type of relationship. Okay, so then there are two more you can say that arguments to support this uh, agency theory. For example, conglomerate firms. So conglomerate firms is in very simple word, you can say that one big company has so many small companies. Okay, so what happens that one big company, if he has so many branches or so many businesses, small businesses, they will focus only on some specific businesses. Okay, so it is a problem. For example, you have a big company and you are making mineral water, and also you are making medicines. So I have invested in your company which makes mineral water, but you will not focus on the mineral water because more profit is coming from the medicine. It is fine, but it is not good for me because I invested in the mineral water. Okay, so that's why we need members of board of director or principal agent kind of relationship, so that you should be paying attention on all of your businesses. Okay, so that is also an argument that why we need principal agent relationship. So I want you to focus as much as you are focusing on your medicine business. I expect you to focus on your mineral water business as well, because I have invested in the mineral water. And then transactional cost economics. What is a transactional cost? Transactional cost is that when you produced any product, when you produce, let's say, mobile phone, you produce it into different steps. For example, you need plastic, you need mechanics, you need electronics, you need a software, you need packing, you need distribution network. Okay, so principal agent relationship is important to decrease the cost of these transactions. For example, when you manufacture your product, you have to pack it, and for packing you pay certain amount of money, and when you have packed it, then you need to deliver it, for which also you pay a certain amount of money. So these small money which you are paying in different transactions, business want to keep them minimum. Okay, so to keep them minimum, these transactional cost, we need a principal agent relationship. Okay, so this is the background of agency theory. Sometimes or before going towards the agency problem, uh, this is a very simple understanding of principal agent relationship. So you are a principal hire the agent. So who is the principal? Investor is a principal who hire the members of board of directors. So he gives them power, and in return, agent perform on the behalf of principal. Okay, but both of them, they have their own self interests. They have their own self interests. Sometimes it happens that both of them, principal agent, don't work for each other. Agents start thinking that he is more important. Even though he is appointed by the principal, agents start thinking that he is more important than the principal. So before going towards uh, further explanation of this thing, let's look into the principal agent relationship inside the business. So shareholders who are the principals, they appoint managers. Managers act as agents for the principal. Now these managers, they can appoint more managers. Okay, so shareholders or the stakeholders, they appoint managers, manager appoints other managers, other managers appoint other managers, other managers appoint other laborers. So in the company, we can see this principal agent relationship at all the stages. At all the stages, we can see this principal agent relationship. So sometimes it happens that members of board of directors and shareholders, they have conflict of interest. Conflict of interest emerge among themselves. Shareholder want something, but members of board of directors, they want something else. For example, shareholders want to maximize their profit. Shareholders have invested in the company, so they want maximum profit on their share. But on the other hand, members of board of directors or the company's management, they don't want to increase the profit. They don't want to give the dividends. They want to, let's say, buy a new building, or they want to make a new asset for the company. Okay, so this leads to a problem. Shareholder wants their money back with profit, but members of board of directors, they don't want to give their money back, and also they want to give minimum profit, so that the extra money and profit they could invest back into the company. Okay, so that's why there is a conflict, sometimes a conflict between principal and agent emerge, which is called as agency problem. Okay, so conflict of interest between principals and agent, this is called as agency problem. Firms have increasingly bestowed power and control over firm assets to professional managers who are not owner. So professional managers who are running the company, they are not the owners. They are not owner of the company, they are just workers. But what happens, these people who are the managers, they start thinking that company is running because of us. We are the most important people in the company. So this understanding of managers thinking that they are more important leads to this agency problem. Okay, I have been raising cattle on this land for 50 years. I think it's safe to call it is mine. Okay, so this is an example. So manager is working in the company for 50 years, and now the manager think that this is his company, but it is not his company. He is just a servant of the shareholders. Okay, so sometimes this type of understanding develops in the manager's mind, that they are more important than their owners, and this is called as agency problem. Did you understand?
Yes, it's clear.
Okay. The next theory is, the third one is stewardship theory. Stewardship theory. So very simple understanding of stewardship theory is that steward is a kind of leader. Okay, he is the caretaker, he is a leader, you can say. So stewardship theory says that the members of board of directors, uh, they are responsible towards the assets of the company. It is a very simple understanding. Okay, so stewardship theory says that the members of board of directors or any type of leadership should lead everyone. Okay, they should act as a leader, and they should think that if the company will go up, I will go up, and if the company will go down, I will also be destroyed. This is the idea behind stewardship theory. So we expect from the members of board of directors or the leadership of the company to act as steward, that if the company will go up, we will go up, if the company will go down, we will go down. So good companies, you can see this stewardship spirit among the leadership, that they don't care about maximizing their own personal profit, they don't care about their own salaries. What they care about, they care about the company. So they know that if the company will make profit, automatically their salaries will go up. So if the company will make more money, their salaries will increase, they will be happy. On the other side, the you have seen most of the time we don't care about the company, we don't care about the organization, we don't care about our job, yes, job place, we don't care about them, we just care about our salary. This is a wrong approach. Stewardship theory expect that we should work for the company, we should work for the organization, we should work for the business, and we should have this thing in our mind that if the business will go up, we will go up. Here is a comparison of agency theory and stewardship theory. In agency theory, the model of the man is economic man, and in stewardship theory, the model of the man is self-actualizing man. Self-actualizing man in the sense that he knows that his profit and loss is connected with the profit and loss of the company. Okay, so there is a there is a comparison. I will share these slides and you can read it by yourself, and I will move to the next part. The fourth theory is embeddedness theory. Embeddedness theory. Okay, so in very simple words, I am not going to read this, but in very simple word, embeddedness means connectivity. So embeddedness theory says that the leadership or the managers or the members of board of director should be embedded into the society. Okay, so over time agency relationship become established in a web of social and personal relationship. So we expect the members of board of directors or the leadership to have good relationship with everyone. So we want our leadership to have good relationship with everyone and use these relations time to time for the benefit of the company. This is the idea behind embeddedness. Once again, what is embeddedness? Embeddedness says that the leadership should have good personal relationship with everyone in the society, and they should be using these relationships for maximizing the profit for the company. Okay, so did you understand embeddedness? Embeddedness, once again, the members of board of directors or the managers or the leadership should have good relations with everyone in the society, and they should be using these relationships for the benefits of the company. Okay, so this is the idea behind embeddedness theory. So this is a case. This is a case, and I will just skip this because we don't have time. And I will go quickly to the next theory, which is stakeholder theory. So what is a stakeholder theory? As the name suggests, that stakeholders. So a theory with multiple principles is a stakeholder theory. Stakeholder theory says that the company has multiple people or multiple individuals or multiple organizations which have some sort of stake in the company. So stakeholder theory says that the company should have good relationship with its stakeholders, but for the sake of ease, you can divide these stakeholders into two categories: most important and less important. So you should take care of your most important stakeholders. On the other side, you should not be ignoring your least important stakeholder. So who are the more important stakeholder for a company? If there is a company, who are the most important stakeholder? Your employees are important stakeholder, your director are stakeholder important. Yes, uh, the people who have given you the money, they are important stakeholders. So you should pay attention on these important stakeholders. On the other side, you should not ignore least important or less important stakeholders, such as media or environmental and pressure groups. Sometimes it happens that we completely ignore them, but the stakeholder theory expect us to pay importance on them as well. Okay, so types of common stakeholders: there can be many stakeholders. So stakeholders could include shareholders, debt holders, employees, managers, government, customer, and local communities. These are very important stakeholders, and we expect that the company should take care of them. Company should pay attention on them. Okay, so once again, what I was saying, paying attention on your stakeholder, you can say that your stakeholders belong to different circles. Some of them, they are close to you. For example, bankers who have given money, shareholders who have invested money, directors who are running the company. So these are the people who are close to you. Customer and employees, they are after these directors, they are also very important. And then it comes supplier, regulators, and government, environmental organizations, and human rights organizations, society, media, and so on. So according to the stakeholder theory, you should take care of those people who are close to you. On the other side, you should not ignore these people or these elements who are apparently not close to you. This is the idea behind stakeholders. Okay, so this is an even more elaborated understanding. The firm has these important stakeholders, so you should take care of them. Your financer, supplier, customer, communities, and employees, these are very important. Without them, company cannot work. So you should pay attention on them. And these things, NGOs, environmentalists, government, media, others, and critics, they are also stakeholder, but they are not as important as those who are in this inner square. Okay, so overall conclusion and summary, I will not read it. I will just explain it in my own words. So once again, ladies and gentlemen, the theory, first theory, social contract theory. What is the social contract theory? Social contract theory says that the companies who are making profit inside the society, they should also think about the society as well. Okay, so if they are making profit, they should return this profit, or they should also do something good for the benefits of the society. This is the idea behind social contract theory. The next theory which we discussed, it was the stewardship theory. What is the idea behind stewardship theory? The idea is that the leadership should act for the benefit of the company. They should not think about their personal benefits. So the leadership should think about the idea that if the company will go up, we will go up. If the company will go down, we will go down. So they should try their best to maximize the profit of the company, and ultimately they will also be getting benefits out of it. This is the idea behind stewardship theory. Then we discussed about another theory, which was stakeholder theories. So the stakeholder theory says, there was another theory, embeddedness theory. Embeddedness theory says that the leadership or the company in general should have good relationship with everyone in the society. They should make personal good relationship, and they should be using these relations time to time for the benefit of the company. And then we discussed about next theory, which was stakeholder theory. Stakeholder theory says that company has different stakeholders. Some of them, they are important stakeholder. Some of them, they are least important stakeholder. So company should take care of their close important stakeholder. On the other side, company should not ignore the least important stakeholder or less important stakeholders. This was the idea behind stakeholder theory. So ladies and gentlemen, these were some of the theories, very important theories from the corporate governance perspective. And now I will just move to the next topic. So did you understand something about the theory part? Hello?
Yes, yes, sir, it's clear.
Okay. So let me now the next topic is interesting, and it is less boring, and also it is very important. It is about the role and structure of board. The role and structure of board. Okay. So in this part, we will differentiate between governance and management structure at the firm. If you remember, yesterday we discussed about this, that managers, they work under the board. They work under the corporate governance structure. And I showed you the relationship between investors and members of board of directors and then the management. Today we will revise this as well. Okay. Then we will discuss about the functions and responsibilities of board and its committees. Different types of boards. This is very important. We have two types of boards: unitary board and two-tier board. Unitary and dual board. Uzbekistan has a dual board system. I will discuss about them as well. And then we will also discuss about different types of ownerships. For example, family ownership, family owned enterprises, mutual and state owned organizations, and corporate governance structures in them. We will look into this. So how the corporate governance started? What corporate governance started from the early joint stocks firms. Yesterday we saw an example of South Sea Bubble Company. So when the business flourished, when the sea routes were discovered, the trade began between far distant places. Then companies felt the need of investment, and to raise this money, they started selling the shares of the company, and joint stocks firms, they came into existence. And when the shareholders and you know, shareholders, they are not business people, they are just rich people. They don't know anything about the business. Yes, they just simply invest in your business. So they also felt a need that we should have some of our own people inside the companies who should be giving us the actual holistic image of what's going on inside the company. And from there, this concept of corporate governance emerged, that the joint stock companies who are using the money funded by the individual investors, they appointed boards so that the board can give information or can increase the communication between management and the shareholders who have invested money. So this is the idea behind how the corporate governance began. So incorporation, when we say incorporation, it's mean formation of a new company. And incorporation is abbreviated like INC in the US and Canadian business name. In our understanding, you have seen LTD, limited, yes, or something like this, PVT, private. So similarly, when you will see into the US and Canadian businesses, you will see INC, which means an incorporation. Okay. So how we can make company? In England and Wales, company can be made by crown and the grant of a royal charter. So the king or queen itself can make company. They give a specific order, and by this order they can make a company. For example, BBC is a news agency, Bank of England, or British Opera. These are some of the examples. These are some of the companies which are still existing, and they were made by the specific order of the royal. In our understanding, sometimes a presidential decree, you can see there are so many agencies and departments. President sign a document, presidential decree, and he can ask to make a new company. So this is the idea behind this royal chart. How we can make company? By royal charter or by the specific order of the top leadership. This is one method. Then you can make a company by parliament or Oli Majlis. Sometimes they also sign specific decree, and they also ask to make specific companies. And then the most common method is incorporation of company by registration under the Companies Act. So Uzbekistan also has a law which specifically provide the information about the formation of companies. So according to that law, you can go and you can register your company in Yagana Darja or one window operation. You can go there, you can give them documents, and they register your company under the specific law of Uzbek Republic. So this is the most common method through which you can make a company, ladies and gentlemen. And these are some of the questions which you should memorize, which are very important. What is the board of director? What is the board of director? Okay, so in Russian, you might have seen the word, you might have listened the word uchreditelya, which is basically the board of director. Board of director links the management of the company to its investors. Okay, so board of director links the management of the company to its investors, those people who have invested money into the company and those people who are working in the company. They are connected with each other through the board of director. Board is responsible for strategic planning, monitoring, supervising, accounting for, and decision making. These are the functions of the board. Board provide entrepreneurial leadership and business values for the company. Directors are employed to give the firm the benefits of their particular skills, past experience, and profile, which means that members of board of directors, they are selected based on their skills, their experience, and their profile. Yesterday I told you that if this is a company which makes halal products, yes, then what type of director you need? You need a director who has religious information. Okay, so you will ask a member of clergy or religious people to come and sit as the member of board of directors. If you are making a university, what type of people you need? You need experienced academicians, educationalists. So you will ask highly regarded academicians or educationalists to come and sit as a member of board of directors. So directors are employed based on their skills, past experience, and profile. Now, ladies and gentlemen, these are this is very important picture, and many of you who still are confused between what is a management and what is a board. Yes, for you, this is picture, this is very important. Okay, so just focus on this. What is the management? On the left side, you can see management is the day-to-day functioning labor force of the company. And on the top sits CEO, Chief Executive Officer. So Chief Executive Officer, he may have other, people who are working under him, for example, HR manager, financial manager, social media manager, yes, auditor. So this is the management of the company. And here on the right side, you can see board and management. Okay, so in this you can see that board in a circle, it consists of these outsiders who are not working in the company. They don't come to the company every day. Okay, so they come to the company only when it is needed, only when there is a meeting of board of directors. So this board consists of some of the people from the management, but most of them, they are outsider who are engaged time to time. Okay, so the people who work in the company and also sit in the board, they are called as executives, and those who does not work in the company, they are called as non-executive directors. Okay, so this is a differentiation between board and the management, and executives and non-executives. Once again, management is those people who run the company, and CEO is the top member. Whereas the members of board of directors, they are divided into executives and non-executive directors. Executives are those people who also work in the company and sit in the board, whereas board has so many non-executive directors who are not worker of the company, but they are engaged whenever it is needed. Whenever there is a meeting, we call them and they come and the meeting happens, and they make policies and strategies and other things which are required. So this is even more elaborated understanding of what we discussed previously. Stakeholders. Who are the stakeholders? Their shareholders, creditors who have given money, employees, and society. So these are the stakeholders. Stakeholders appoint monitors. Monitors are members of board of directors, who then appoints the controllers, who are the managers, and they control the day-to-day functioning of the company. So this is a relationship between stakeholders, monitors, and controllers. Investors appoint members of board of directors. Members of board of directors appoint CEO and the other managers who work in the company on day-to-day basis. Did you understand, ladies and gentlemen?
Yes.
Yes.
Okay. So types of directors, very quickly. Two types of directors I have told you. An executive director is a board member and also a firm executive. Okay, firm executive means he comes and work in the company every day. So he is the worker of the company and also he is the member of board of directors. Non-executive director is a board member without executive functions, which means he does not work in the company and he comes and sit only in the board whenever it is needed. So non-executive directors, we call them independent and outsiders. Yes. And non-executive directors, usually they are expert in their own domain, and we hire them or engage them for a specific function in or specific role which is assigned to them in the company. Okay. So directors, a director is a part of a collective body of director called the board, responsible for superintendence, control, direction of the affairs of the company. Okay, so this is the definition which is written in Companies Act 2006 of UK. So in this act, a director include any person occupying the position of director by whatever name we call. We can call directors as directors, we can call director as with any other name, but these are the people who do what they are responsible for: superintendence, control, and direction of the affairs of the company. These are different types. Very quickly, executive directors, I told you. Executive directors are those directors who work in the company. Non-executive directors, they don't work in the company on day-to-day basis. They occasionally come and sit and meet. Then we have shadow director. Shadow director, as the name suggests, shadow. Shadow means he is the shadow of the original director. Okay, so original director is someone else, and this person is acting on the behalf of this director, and we call him shadow director. For example, your father has a company, but he does not come to the office, and you as his son or daughter, you are working on the behalf of your father. So you are a shadow director. Okay, so shadow director means he is the shadow of the original director. De jure, the legal director, your father will be the de jure director because he is the owner. And de facto director means the person who is running the company. Originally he is running the company, but he is not the legal owner of the company. Similarly, the chairperson, ladies and gentlemen, as the management has a leader which is called as CEO, management has a leader which is called as chief executive officer. Similarly, the board has a leader who is called as chairman. So chairman of board of directors, you might have heard this, chairman of board of directors. So who is the chairman? Chairman is a title. Among the directors, they select someone as a chairman, and chairman leads the meetings of the board. So board of directors is chaired by one of the director who is called as chairperson. Okay, ladies and gentlemen, what are the duties of the directors? The people who sit in the board, what are their duties? So these are their duties, very important duties. Statutory duties by law. By law, they are expected to do compliance. They are expected to adhere to the company law, health and safety law and regulation. This is their legal duty. Fiduciary duty means moral duty. The moral duty is to act in good faith and probity, means it is their moral responsibility to think about the benefit of the company and the people who are engaged with the company. They are also the agent of the company, which means they create legal obligations. Also, it means that they respond to the requests of stakeholder. They report back to the stakeholder. Then it is also the duty of the members of board of directors to declare any conflict of interest. For example, if I have my university and you invite me to sit as a member of board of director in your board, and you also have a university, so it's mean that we have a conflict of interest. I will think about my own business. I will not think about my competitor's business. Okay, so these types of conflict of interest should be declared in advance by the directors. Director should be accountable, and it is the collective responsibility of the board that they should act not individually but on the behalf of the board. So whatever good will happen, it will be because of their collective responsibility. Something goes wrong, it will also be the collective responsibility of the board. These are the duties. Okay. uh, Different roles of board of directors, what they do actually, what are their role. So their function is monitoring and advisory. They approve the corporate strategy. Strategy means they make a plan, short-term strategy and long-term strategy. They test the business model, identify the risk, plan for new executive, design the executive compensation packages, means salaries, how much salary will be given to which person. They ensure the integrity of published financial statement, which means yesterday I told you that there is an internal audit report which is prepared by the management. Now management will always say that everything is well, everything is going very well, we are making profit, but members of board of directors, they recheck this report because they are responsible to give an accurate image of companies functioning to their stakeholders. Okay, so they recheck this report. So this is about financial statements. They ensure the integrity of published financial statement, approve major assets purchase. So whenever the company has to buy or sell something very big, they call a meeting. For example, you have a business, so you are doing merger and acquisition, or you are buying or selling a big building, or you are planning to open a new business domain, or you are selling uh, a product which you want to close, or you want to relaunch or launch a new product. These are very big decisions. For these decisions, you call the meeting of the board. Represent the interest of the stakeholder, we already discussed about this, and ensure the companies comply with laws and codes. This is very important, that the board has a supervisory function. They should see that the management is abiding by the rules and regulations, um, not only governmental rules and regulations, but also internal rules and regulations which are made by the company's management. So, ladies and gentlemen, please pay attention to this. There are four important functions of the board. They provide accountability, they do monitoring and supervision, they make strategy, and they make policy. So these are the main four areas of action, domains, the roles which the members of board of directors they do. Now here is a comparison. This is normative and this is functional. You can say that on the right side you can see that what happens, they spend most of their time on monitoring and supervision, and they spend less time on strategy formation. On the left side you can see how directors should spend their time. Ideally they should be spending more time on strategy making and less time on accountability and monitoring. But what happens, they spend most of their time on monitoring and supervision, accountability, and less time on strategy and policy making because of the human psychology. Yes, we are very conscious and we want our supervisory role to be dominated. That's why we don't think about future, we think about present, and for present we love to monitor and supervise the people who are working under us. So this is the normative and positive experience of board actions, means what ideally they should be doing and what they usually do. So ladies and gentlemen, this is very important slide which I am showing you right now. So this is about the construction of the board, what type of people we need in our companies, what they do, and from which areas they belong. First of all, we need insiders. If you want to make a board, you need insiders. Who are the insiders? Insiders are the people who work in the company. They have specific knowledge about management, finance, and law. So we need insiders. Then we need business experts. Business experts, they have similar business as of your own business, and they provide their business expertise with regard to your business. Then we need sports specialists, sport who provide technical support, for example, lawyers, banker, insurers, public relation expert. We need these people in our board. And then you need community influential. I told you yesterday as well that these actresses, sportsmen, Instagram models, influencers, sometimes you need them as well. Okay, if it is a university, then you need university faculty as your member of board of director. If political leaders, sometimes you need as member of board of director. You need clergy as member. Clergy means religious people. And I gave an example of halal product. If you are making if you are opening a company of halal food, then you may need someone with religious knowledge as member of board of director. So this is the construction of your board, what type of directors from which categories they belong, and what type of directors they are, and what they actually do. Then when you have collected these people as member of board of director, then you will divide them into different committees. So among these people, you will make different subcommittees, committees to perform specific functions. For example, auditing, remuneration, and nomination. Auditing, as I told you, that management will prepare an internal audit report. This report will be rechecked by the members of board of directors through their own auditors, or they can hire an external auditor. This is done by the audit committee inside the board. Remuneration means the people among the members of board of directors, they decide the salaries and compensations of the members of board of directors. And then nomination committee functions, as the name suggests, that they nominate new members of board of directors, maybe chairman, appointment of CEO, or the main appointments in the company's leadership, management leadership. This is usually done by this committee, which is called as nomination committee. So once again, audit committee does the audit, recheck the audit report prepared by the management. Remuneration committee decide the compensation package, how much salary will be paid to which director, to the CEO maybe, or sometimes they pay in shares, sometimes they give profit share. So these sort of things, financial distributions in terms of compensation, will be decided by the remuneration committee. Nomination committee will decide the new members of board of directors, appointment and removal of the people on important posts within the firm. This is done by the nomination committee. Okay, there are differences between different board styles. Ladies and gentlemen, we have divided into three categories. These are three main legal structures as well. So in Anglo-Saxon or the common law regimes, UK and USA, the board is single tier. I will just explain you what is single tier and two tier. It is the combination of executive and non-executive directors. and the function of the board is that it supervises the managers, and then it has different subcommittees. In Europe, mainly in Germany, the board is two tier. Upper tier supervises the lower tier supervises the managers. I will explain this two tier system. And in Asia, we are also in Asia, mainly Japan. Uh, there is a huge influence of cultural expectations. So just think about any board in Uzbekistan or in my country, Pakistan, or in any other neighboring country in Asia. When we think about leadership, when we think about top management, what type of people come in your mind? When you think about top leadership, what type of people comes in your mind? They will always be male. They will always be old. Yes, some of them, they will be retired. So this type of things come in our mind whenever we think about leadership. Yes, old people, experienced people, mostly males. Okay, so this is our cultural handling of this phenomena, that our culture does not like females to be in the leadership positions. Our culture does not like not culture, but it is not socially acceptable to have youngsters or females as members of board of directors. Okay, now ladies and gentlemen, this is very important one tier and two tier system. One tier and two tier system. What is one tier system? One tier system is that these shareholders, the principal, appoint board of director. Board of director then appoint management. So between the shareholders and between the management, there is just board. There is just one structure, which is board. So this is called as unitary board structure. When the shareholders appoint directors, board of director, and board of director appoint management. So this is one tier system. One tier mean between shareholders and management, there is only one structure, which is board of director. That's why we call them one tier system. Then we have two tier system. What is a two tier system? The two tier system is this. Shareholders, they appoint a supervisory board. Supervisory board appoint board of director. Board of directors appoint management, and management then appoint other managers. Okay, so shareholders and management, between shareholders and management, we have two structures, supervisory board and board of director. That's why we call it a two-tier system or dual board. Once again, shareholders, they appoint supervisory board. Supervisory board supervise the activities of board of directors. Board of directors supervise the activities of the management. So between shareholders and between management, you have two structures. That's why we call it dual board or two-tier model. Did you understand? Did you understand the difference between single tier and two tier?
Yes, it's clear.
So once again, shareholders appoint board of directors appoint management. This is the single tier or unitary system. Here you can see this gray area is investors or stakeholders. They appoint board and board appoint management. They stakeholders appoint supervise the board of directors supervise the management. Okay, so this is the single tier system. One more understand that the corporation appoint board of director and board of directors, they directly supervise different domains of the company's activities. This is also a unitary system, whereas a dual system or two-tier system is that shareholders appoint supervisory board appoints board of director then appoint management. So between shareholders and management, there are two structures. That's why we call it two-tier system. Okay. So different forms of the board. Unitary boards dominate in UK and USA. Single executive board that contains all executive and non-executive. In USA, unitary board tends to have few executive directors. In UK, unitary boards have a fairly even split between executive and non-executive. Executive, you remember, executives are those who work in the company. Non-executives are those who does not work in the company, and we engage them time to time whenever there is a meeting. Dual boards have an executive board and a separate supervisory board. A dual board has a better division of responsibility. Stakeholders appoint supervisory board appoints members of board of members of board of directors then appoint management. So all of them, they have their own functions and the responsibility is divided between all of them. So different basic board structures, there are 4 categories. One type of board is all executive board. All executive board means all the members of board of directors, they are also working in the company. CEO, financial manager, marketing manager, HR manager, all of them, they are working in the company and also they are the members of the board. So we call it an all executive board. Then we have an executive majority board, which means most of the members of board of directors, they are working in the company, but sometimes you hire some outsiders, but these outsiders are much less in numbers than the executive members. So this is called as an executive majority board. Then you have an executive minority board. Mostly you can see these types of board. Executive minority board means the members of board of directors, the split between executive and non-executive is in this proportion that executive are less in number. So the people who work in the company on day-to-day basis, like CEO, financial manager, they are the members of board of directors, but other people who are not working in the company, they are more in number. Okay, so when you make a board, you find CEO there, maybe financial manager is there, but majority of the members of board of directors, they are outsider. And then you have non-executive board, which means that the whole board is outsider. None of the members of board of director is working in the company. So the board is an outside board. Okay, so this is called as non-executive board. Then board size, ladies and gentlemen, how many people we should have? How many people we should have as member of board of director? Different countries have different requirements, and different countries by law expect a specific range of people. For example, in Uzbekistan, most of the board member, 8 and 9 board members, you will see they are considered as an ideal board if there are 8 or 9 people in the board. Okay, so board should not be very small, it should not be very big. And the size of the board, it matters that how many people you should hire as members of board of directors. So this is a comparison between different countries. You can see different countries have different numbers of people. For example, in Belgium, Denmark, Finland, average size of the board is 8 to 9 and 10 people. Yes, so you have 8 people, 9 people, 10 people as members of board of directors. Some of the big boards are in Germany. Germany is 2-tier system. Russia has 10 people. Yes, so France 13, 14 people. These are the big boards, but this is the average board size in different countries. USA and Canada, it has 11 people as members of board of director. You can have 11 people as members of board of director. So it is about size. Here is a comparison between different countries, smaller and bigger boards. You can see the Germany, 15 people, very big board, 15 people, and Belgium, 15 people as members of board of director, whereas Brazil and Switzerland, 6 people, these are considered as smaller board. Okay. Outside directors. Outside director means non-executive members. How many people you should be hiring from outside of the company? In Japan, 1 people. In USA, 5. Hong Kong, 2 people. Brazil, 3 people. Yes. And outsider directors means they are not working in the company. And I told you that Asian societies being very conservative, they tend to hire less people from outside. So Japan and Hong Kong, Brazil, you can say also Latin American traditional society have less probability that they will hire outsiders as members of board of directors. Diversity, a little bit about diversity. So I told you yesterday that diversity is very important in the board. Not only, I'm not only talking about females, but I am also talking about geographical representation, age, qualification, experiences, skills. They also bring diversity. So diversity is very important in our board. In our firm, there should be diversity, and diversity will increase the profitability. Yesterday, I told you. So here you can see a comparison between different countries in terms of gender diversity. So you will see that in USA, 26% female directors are usually there. In UK, 31%, like Norway, Denmark, Sweden, Scandinavian countries, they have the higher proportionality of female directors. And female chair means the chairperson of the board. You can see that Scandinavia is leading. Scandinavian countries, they have more female chairpersons. So this is about diversity. If we talk about their age and tenure, you will see the age ranges between 59 to 61, 62. So most of these people who are the members of board of directors, they are retired or about to retire. So very experienced people, they become the member of board of director. And how long they stay members of board of director? 8 years in USA, in UK 4.4 year, yes, in Canada 7.3 years. This is their normal tenure as member of board of director. When they join the board, then they stay in the board for 8 year, 4 year, 6 year. This is the average tenure of these people. Then we can see geographical diversity and education. The most educated board are in Europe and Asia. The least educated boards are in Australia and North America. Mostly, my assumption is that these countries have family-owned enterprises, and when you have a family business, you don't care about the education. Okay. Whereas Europe and Asia, multinational companies, very competitive business environment, skill-based recruitment, it leads to the higher qualification of the members of board of directors. So the education also matters. Diversity in terms of foreign directors, you can see different countries have different percentage of foreign directors. For example, the highest number you can see Ireland, 10 to 11% foreigners can become the member of board of director. And if you go into the least probability of a foreigner to become a member of board of director, you will see Taiwan and Qatar. These are traditional society. Whereas you can see USA, 27.50% foreigners in the members of board of directors. Means foreigners have higher probability to be into a key leadership role in the company. Okay. Why are women underrepresented on boards? why we don't have many females. There are certain stereotypes as well, but there are some of the genuine concerns which are deeply embedded into cultural heritage, value system, standards, and preferences of the geographical region, or just because of the female's own assumption or lack of struggle to be in a key leadership position. So these are some of the reasons that why women are underrepresented on board, which sometimes leads to serious legal consequences. The first reason which is given, it is institutions. Sometimes it happens that in your company females are discriminated, and that's why no one wants females to be in the key leadership roles such as members of board of directors. Females are considered as weak. That's why the the members of board of directors or the appointment committee or nomination committee, they don't consider females candidacy as a potential member of board of director. It is a common type of discrimination at workplace. Then glass ceiling. Glass ceiling means from female perspective and from male perspective, we have certain threshold. Ceiling means roof. So we have we have kept limits for the female. We think that if she is a girl, she can maximum become CEO, okay, but she cannot become member of board of director. These are our ceilings or thresholds. They are motivated by so many factors, you know about them already. So we create limits. We have made limits for the female. That is the reason that there are very less chances that females will become member of board of director. Then gender self schema. Gatekeepers have views of gender appropriate roles that bias executive selection. This is very important. Gatekeeper. Who is a gatekeeper in the company? Financial manager is a gatekeeper, accountant is a gatekeeper, lawyer is a gatekeeper. So what is the idea? Sometimes it happens that lawyer of the company, he says, don't hire a female because she will have more legal complications. Are you agree with me? Females have more legal complications. Anyone? No?
Yes, they are.
How?
They can get pregnant, so they will leave job, and still their salary will be paid.
Yes, you are right. So female have more legal complication, financial complications, and so on. That's why the gatekeeper, the accountant or the financial manager or the lawyer will say, don't hire the female or don't give him a key leadership position. She will become sick every month and she will go for leave, maternity leave, and we have to pay for this. So it is better not to hire this female as a member of board of directors. Yes. So as I told you yesterday that there are certain benefits as well of females on board. I will not read this, but I will just give you my own opinion. Yesterday also I shared this opinion with you. I think that if you have more females in company will perform much better. The reason is that females are more detail oriented, and it gives a very polite and neutral image of the company, and investors love to invest in a company which has a very polite and neutral image. If there are all the males or male dominated leadership structure, investor will think and do risk management. But if there are diverse, if there is a diversity between the top leadership, females are there, investor will feel more confident in investing in this company. So that's why there are benefits as well. Here is an experiment, the output of a study. What they wanted to do, they wanted to hire teachers for teaching position. So you can see that if there are 3 male and 1 female for a job post, then there is zero probability that this female will be selected because you have more males. So one of the males will be selected. It's mean that when there is a male available for a job, we don't consider female, okay, because we have a male. Our top priority is to hire a male. So this is a bias which impact on hiring decisions, and most of the time it happens like this. So women own board. Davies report from 2011 to 2015. This person, he proposed some idea related to the diversity, and his evidences suggest that the companies with the strong female representation and at board and top management level performance, they perform better than those without. The thing which I was saying, that if you have more female, the performance will go up according to the Davis report. And then later something very interesting thing happened. We have this Hampton-Alexander review. Hampton-Alexander review is the review of the Davis report, which said that by the year 2019, the top performing firms should have 33% of the female. And now it has been proved. If you look into different ranking and indexes of top performing firms, you can see that there are at least 33% females, which is the proof of Davis report, who said that if the company have more females, the performance will go up. So Davis report is supported by Alexander Hampton review, and today we can see that it has been proved that the top companies, the companies who are performing very well, they have at least 33% females in the board. Okay, ladies and gentlemen, this was another part. Are you still with me?
Yes, sir.
Okay, so now let's discuss about corporate governance in different part of the world. Okay, corporate governance in different parts of the world. Do you need a break, or should I just continue?
No, you can continue, sir.
Okay. Corporate governance in different parts of the world. And ladies and gentlemen, I will begin this with giving an overview of different legal system for making a background. Okay, so there are different legal systems, as all of us know that there are two big domains, two big categorizations of legal system. One is civil law and other is common law. So we divide them as well, civil law countries and common law countries. Civil law is also called as Roman German law. Also we call it case law. Whereas common law is called as Anglo-Saxon law, and we also call it case law. Sorry, civil law is called as code law and common law is called as case law. These are the big families. Then we have some of the other smaller influential legal families. For example, Hindu law, canon law. Canon law is Bible based, inspired by the Bible. And then we have Jewish law and Islamic law, which we call as Sharia law. So these are some of the main legal families. Civil law is Roman German law, or civil law is codified law. What are some of the specifications of civil law? So you know that what happens in civil law countries, you make laws in advance in the codified form. You make laws in advance in the codified form, and then the judge will look into these written laws, which has already been written by the experts, approved by the lawmakers. So whenever a case comes, the judge will open the book and look into into the specific code and will decide the case according to this specific code. This is the feature of the civil law. On the other side, English or common law is formed case by judges. Each case is considered as an individualistic, each case is considered as a different case. There are written laws in the books as well, but the salient feature of common law is that judge will look into the background of the case. He will listen both parties. According to the facts, he will decide the case. So this is the feature of common law. And when he will give a judgment, this judgment will become a new law. And the future cases of similar nature will be decided according to the judgment which has already been given by another judge. Okay, so this is the main feature of the common law. The salient feature is the system of precedent. Judge give judgment, and this judgment become a law for the future cases. So which nations adheres to different legal families? Common law, you can see that India, Pakistan, UK, USA, these are the common law countries. French civil law in the French colonies, you can see German civil law in Austria, Japan, South Korea, Taiwan, in China as well. And I would say that Uzbek or the Soviet style of civil law is also very much influenced by the German civil law. And then we have Scandinavian civil law, mainly in Scandinavia. So these are some of the legal families and the countries which adhere to these legal families. Okay. So besides this, we have socialist and Islamic law. Socialist law is also called as communist law, whereas Islamic law is called as religious law or Sharia law. Okay. So the countries such as Saudi Arabia, they have Sharia law. Then inside the Sharia law, there are two versions of Sharia, Sunni and Shia. Shia Islamic law you can find in Iran, for example, and Sunni Sharia law you can find in many countries. And then socialist laws, mostly in post-Soviet countries, you can find socialist law. Or these countries, they consider themselves as civil law, and many of the post-Soviet countries are now trying to incorporate social common law inside them. For example, in Kazakhstan, there is a financial center, Astana. They have opened a financial, you can say that free trade zone type of thing, in which there is common law. Okay, so in civil law countries, you can see that different countries are trying to incorporate certain elements of the common law. So here you can see the distribution of different legal systems. Mostly in most part of the world, we have civil law, and in comparison to this, the second important is the common law countries. Okay, so characteristics of legal families, I have already discussed about them. In terms of businesses, it is very important that common law countries, they have stronger rights against managers, and civil law countries, they have weakest creditor protection rights. So in common law countries, the investors, they feel confidence in investing in common law countries. Why? Because each case will be treated individually by the judge, which gives more confidence to the investor. So investors love to invest in common law country because they are not worried about the law. They think that if something will go wrong, judge will listen to me, judge will listen to the facts of the case, and according to the facts of the case, he will decide, he will give judgment. Whereas they feel hesitation in investing in civil law countries, because civil law countries, usually they have made their laws in black and white, they are written in the books, and anything which will go wrong, or anything which will go against the book or beyond what is written in the law will cause a great problem for the investor. That is the reason that investors feel hesitation in investing in civil law country. And also this is the reason that many civil law countries are now trying to incorporate common law into their system. Now we will discuss about corporate governance in different countries. First of all, Germany. In Germany, the German banking system is the critical source for financing of the company. So the German banks, they give money to the companies, or the German banks, they are the key stakeholders or the investors inside the company. So there is a concept which is called as house banks. House banks are the small banks. These small banks, they give money to the companies, and also these executive from the banks who give money to the companies, they become the members of board of directors of these companies. So the bank give money to the company, and also the bank appoints someone on the behalf of the bank to become the member of board of directors. So these banks, they at the same time they act as a creditor, and also they directly participate in policy and strategy making of the company. So this is very interesting phenomena. You take money from the bank, and also you ask someone from the bank to act as member of board of director. Equity ownership in Germany, many German firms have a lot of non-voting, restricted and multiple voting stocks. Means they buy the stocks of the companies just for the sake of investment. They don't want to influence on the company's decision. They don't want to participate in the voting process. They simply buy the stocks of the company for the sake of investment. And sometimes it happens that you don't know who has invested in the company. Okay, so this is very interesting about the German style of corporate governance. Then we have Japanese style of corporate governance. This has a specific name which is called as kairetsu. Kairetsu. Kairetsu is a network of Japanese firms established around a major industrial firm like Honda, Toyota, Mitsubishi. In simple words, what is the kairetsu in Japan? In simple words, you can say that these companies who are manufacturing the similar products, for example, Honda, Toyota, Mitsubishi, they manufactures automobile. So these companies, they don't compete with each other. Instead of competing, they believe in cooperation. They cooperate with each other. Instead of coming into competition, they act as friends. Okay, so this is the concept of kairetsu in Japan, Japanese style of corporate governance. So the Japanese, they believe in personal ties, and what happens, instead of fighting with each other, they believe in cooperation. They share their knowledge, expertise, sometimes personal and human financial resources with each other. Why this kairetsu system arise in Japan? Because Japan is a traditional society, and so many cultural factors are influencing on this kairetsu system. So Japanese, they believe in cooperation, they believe in personal ties, they believe in friendship, which is also demonstrated by their corporate governance structure. Okay, what is the negative impact of kairetsu? So if you have cooperation among the companies, and if you believe in no competition, then there is a phenomena which will develop, which is called as zombie firms. Zombie, you know, zombie. Who is a zombie? Zombie is not an alive person. Zombie is not a dead person. So what happens, so many companies, they become zombie. Zombie means you cannot close them and you cannot run them. This company is neither dead neither alive. So this company, minimum making minimum profit, and this profit goes back to the functioning of the company. So it is not making a significant amount of money as profit. That's why we call him zombie firm. So when you don't want to close the company, you keep it running, but it is not making profit. We can say that this is a zombie firm. And this is a negative impact of this kairitsu culture, that you believe in no competition. Because of no competition, company don't care about maximizing the profit, and ultimately it become a zombie. In South Korea, a similar concept, which is called as Chibol. Chibol is a family-based corporate governance. In very simple word, Korean Chibol style of corporate governance, it says that if you have a family member who can act as member of board of director, then you should bring him as member of board of director. So if you have a company and you have your son, daughter, son-in-law, daughter-in-law, brother, sister, nephew, niece, then you should bring them as member of board of director, because your family member can perform much better than an outsider. So you will see most of the South Korean companies, these South Korean companies, they are family businesses, and very big companies, for example, LG, Samsung, they are family owned enterprises, or Hyundai, Korean Air, these are the family businesses. The idea is that the members of board of directors, they are family member, and this is called as Chibol culture. In Italy, in Italy, the thing is very interesting. It is a very strong communist style. On the other side, it has incorporated Catholic ideologies, elements of religiosity. So Marxist and Catholic ideologies are more influenced than market economics. So you can say that even though the Marx said that religion is not good, or he was anti-religion, but still you can see that it is a good combination of religiosity and Marxism, which we can see in Italy. Even though the things have changed, it has become a liberal market economy, but the style, or you can say that the corporate governance, still it is in the hands of the people who have a Marxist and Catholic mindset. And then in France, very close to the German style, they trust the government, which means that the top leadership of the company has very good relationship with the government. So governmental influential, they directly impact on the business. So France has a strong links between government and industry. French government monitors the activities. A Republican or an occasional left-wing elite has long been influential in France since Leon Blum and the Popular Front. So the idea in more simple word is that France, even being a very liberal, democratic, and progressive country, the top leadership has very close ties with the government, and government also has interest in the business activities, and they monitor the activities of the company. In United States, also very liberal, progressive, and democratic country, corporate governance structure is considered as an ideal. But the critics of the corporate governance in USA, they say that there are certain social conflicts which impact on the corporate governance structure in USA. For example, there are some ethnic biases in USA. So USA, even though it is considered as an ideal corporate governance structure, but still you can see that when you have to select a member of board of director or a top manager, some people discriminate against the color or the region or the accent of this person. So you can see that when you if you apply for a university, or if you apply for a job, they sometimes collect data related to your geographical representation, your ethnicity, which language you speak. Okay, so the idea is that the critics of the American corporate governance, they say that these social conflicts ethnicity-based things, they also impact on the selection of members of board of director in USA. Otherwise, it is considered as an ideal structure. Okay, so now we have finished some of these major countries. Now I will talk about the China, and then I will let you go. Do you have any question until now? No question. Okay, so the Chinese corporate governance. Chinese corporate governance, ladies and gentlemen, it is very interesting because China is dominating the economy of the world. China is our neighbor, so that's why uh, we should spend some time in understanding how the China is working. Historically speaking, China passed through a very difficult period. Very difficult period of I'm talking about economic difficulties. So historically speaking, China faced many troubles. Britishers came, and when the Britishers came to colonize the China, what they were doing, they were buying the Chinese products, for example, Chinese silk, tea, spices, and so on. And in return, they were giving them opium. They were not giving them money; they were giving them opium. So the Chinese people, they became addict to the opium. So they were giving them their real products, and in return, they were getting opium. So this was a period of poor China when they had no money at all, and all of them they were smoking opium, and it was considered as the worst period of Chinese history. And this graph shows that for a couple of 100 years they were relying on the opium trade. Means the foreigners were coming buying products, and in return they were giving them the opium to smoke. Okay, then the modern China, there are a couple of benchmarks: Chinese revolution, and then the conversion of Republic of China into People Republic of China, starting from Mao Zedong, and then the person Deng Xiaoping came. So Deng Xiaoping did the reform and opening up. So Deng Xiaoping and Gorbachev. So Gorbachev also did something similar, reform and opening up, perestroika. In terms of Gorbachev, what happened? The things went wrong and Soviet Union collapsed. Soviet Union destroyed. But the reforms and opening up which Deng Xiaoping did, they became very beneficial for China. So in return, in the result of Deng Xiaoping's reforms of opening up, China started progressing. And then this very interesting thing happened, that under the regime of Xi Jinping, China decided to aggressively extend its tentacle towards all over the world and started physically going into different part of the world and establishing their foots. So this is the policy of the Chinese Communist Party, and you can say that that China is now everywhere, and it is not the individual businessmen who are coming and doing businesses in your country. It is a part of the policy, and to fulfill the demands of these policies of Communist Party, they are aggressively doing business with anyone. So the China proposed a Belt and Road Initiative. I think that many of you know about this. So what is this? This initiative is connecting China with the different parts of the world through land and through sea. Through land and through sea. So under this Belt and Road Initiative, China is building seaports in different countries, for example, in Sri Lanka, in Pakistan, in Africa, and also constructing roads to connect the whole world with China under this Belt and Road Initiative. And here is a comparison of Chinese GDP. It is a pre-COVID period. Okay, I couldn't find the recent one. Pre-COVID period, you can see that exponential growth has been observed in the Chinese economy. So, what influenced the Chinese success? Why they became rich? I think that most of the credit goes to the Chinese company law. So the Chinese company law contributed a lot in the development of a modern day China. All of these Chinese high-tech companies, now they are leading, uh, or not only the technological companies, but their financial economical instrument, or their service mechanisms are also leading. And there are two types of people. The world is divided between Huawei and Samsung, or let's say uh, three portions: Huawei, Samsung, and iPhone. So three type of people are living in this world: Huawei people, or Samsung people, and iPhone people. The point which I'm trying to make is that China in the last 30-40 years has demonstrated an exponential growth, and now it is standing side by side with previously considered as the largest economies such as South Korea and America. And once China was ruled by UK, and now you can say that the Chinese economy, the contribution of the Chinese economy into the world economy is much more bigger than the UK. So how it happened? It happened, first of all, their opening up means their vision of reaching out and doing business. And second important thing which contributed to the Chinese success is their business law. So these are some of the feature of the Chinese business law. I will quickly go through this in order to give you an idea that why China is progressing. The first of all, the Chinese structure of Chinese business. So Chinese companies, most of them are state-owned enterprises, state directly involved in Chinese company. And then this is the reason that when the state is there inside the company, they monitor the activities of the company, and they know that what is good for the economy and what is not good for the economy. So this is also very plus point that state takes interest in the businesses, and they want to contribute towards their own economy first of all, and then they take care of what is being imported and what is being exported and what is being produced. Then the incorporation of company and shares are divided between state owners and then the individuals, or the other members of the society. The state participate in the company's formation and also have the highest share or one big portion of the shares of the company. Then the liability is very strict. If you do something wrong, there are very strict liability. If there is a corruption, it's mean that you are dead. So very strict liabilities are there, and this is also a salient feature of the Chinese law: strict liabilities for corruption or misdoings or wrongful deeds inside the businesses, which leads to the success of the company. Management of the organization in Chinese style, you can see that they are very serious about the leadership according to the different philosophical backing. For example, what Confucius said about a good leader, these sort of things, you can see they influence on their selection of the leadership. So leadership in Chinese style means in Chinese companies, leaders are highly qualified, mostly male, retired, experienced people, but good leaders, you can see. And the labor law and Chinese skilled labor. Labor law is very strong, influential on the success of the businesses. I give you an example that in China, it is not possible to come on the street and start doing anything, whatever you want. I mean, you cannot become a laborer. If you want to work as, let's say, if you want to dig a pipeline, or if you want to work as a mason in construction industry, if you want to drive a taxi, you need to fulfill the standard. You have to meet certain qualifications. So it's mean that even the ordinary jobs are done by the skilled people. A tractor driver or truck driver, he is also a skilled person. This is also a plus point. With regard to the Chinese sales, ladies and gentlemen, the China has a central monitoring what is being produced, what is being import and export. For example, this year, if China needs a product inside China, they will not export it because they have their domestic needs. So after fulfilling their domestic need, they will allow you to export this. Then dispute resolution and strong judicial system. If something goes wrong during this business process, the business law supports. The process is very fast. Cases are decided instantly, and in most of the cases, they are decided on merits. So this strong judicial system and strong dispute resolution, effective dispute resolution mechanism also impact a lot on the success of Chinese business. So these are some of the factors which contribute to the success of Chinese business. These are some elements which contributes towards the development of Chinese law, or what are the individual characteristics of the Chinese law. First of all, law and politics are same. There is no distinction between law and politics. Politics is law and law is politics in China. There is even a single word which is called as fa. Fa is for law and politics. They are same things. Law is codified, means the law is prepared by the expert. It is written. Everything is done by the book. Judge will look into the codified law. Law is very sophisticatedly developed, and it guides the businesses. Then flexibility in terms of businesses. If something is practical, Chinese will make laws with regard to this. It is said that in China, practice precedes the policy and policy precedes the law. It's mean that if you can show that something is practical, it is very easy for Chinese to make a policy and to make a law. If you prove that something is practical, they can make policy and law to back this up. And then there are no binding precedent like common law system. Each case is individual case. Each case has its own merits, which are usually decided by the book. So these are the salient feature of the Chinese law. These are the things which contributed to the development of Chinese corporate governance. That is the reason that China is leading in terms of business in the world. So ladies and gentlemen, if you are still with me, let's do one case, or you want to do it as your homework?